So we'll back it up. I mean, I don't know all the ins and outs and the details, but not gay. Is it not gay or half gay, Jared? And I'm not trying to be
But it
funny.
was not gay, Jared. No,
Okay,
that's
so
you're thinking a quarter black,
the quarter Asian lawyer. Okay,
no,
so
half Asian lawyer. There's half Asian lawyer, quarter black. There's
okay,
a whole bunch of politically incorrect.
not gay. Jared stopped working for Crowder, give or take, I'll say 4 or 5 years ago. As he left, he signed what he begrudgingly concedes now was a duly signed, but the contents we don't know, NDA. He signed a non-compete, and it seems that he's been
signed a non-compete previously as his initial part of his employment, and negotiated a modification of that in exchange for giving a full well, he probably had the non-disclosure agreement from the get-go too.
So non-disclosure, non-compete, meaning that when you cease working, if it ever comes to an end, depending on how it comes to an end, if you get fired, they can't avail themselves of the non-compete. You can't compete in the same industry, typically geographically limited, temporally limited. I think now 2 years is give or take the standard. By the sounds of it, Robert, it looked like he was globally enjoined from working in the entertainment industry. I don't know that we know the details definitively yet. And then he alleges that Crowder was using lawfare to silence and abuse him since he left. It turns out that maybe, at least based on some written documents,
in writing, never in writing, folks, never in writing. Don't put your extortion plans in an email or text.
I'm going to try to. I'm not going to play devil's advocate. I'm going to try to steel man this. It seems that there's an email saying, "Look, we know what we're allowed to get under the letter of the law in Texas family law. We want more than that, so we're going to put on a public campaign, a public pressure camp, or a pressure campaign to get Crowder."
That line between litigation strategy and extortion,
and that's the question.
He really crossed that line a couple of times. They were trying to extort Steven Crowder, is what it looks like.
And it looks like you had the ex-employee colluding with his wife in the context of a divorce. One can ask questions there to extort Steven Crowder. That is not the,
but if you ask questions there like the quartering does, not gay Jared, totally against lawfare, will start threatening lawsuits against you because apparently in between not understanding non-competes, not understanding non-disclosure agreements, not understanding extortion, he doesn't understand defamation law. He was threatening with the quartering. If you suggest what you seem to be suggesting, which by the way, he wasn't suggesting. I watched the video. I had no idea that
he's suggesting having sex with Steven Crowder's ex-wife.
Yeah. And quartering, they did no such thing. And it's like, man, that's protest too much. I mean, I initially thought there was a zero credibility to that. And then I was like, now you're making me wonder. You're drawing more attention to this than other people. But, that guy's like a running library of bad legal opinions, bad legal takes.
Straight to making it public.
A little gay when it comes to the law.
Straight to public, public statements in writing, raising money for his legal defense. Hold on, and we're gonna get to the Hillary destroying the evidence. A while back, there was that clip that was shared that
we called it again. By the way, remember when that was first aired? I said I was very skeptical of that clip for two reasons. One, I've represented more victims of domestic abuse than almost anybody out there. So I'm intimately well aware of what that legal landscape and evidentiary landscape looks like. And I was like, the only big inflammatory piece you have on Steven Crowder is a clip out of a bad argument. Every relationship, if we took all of our relationships across America, I guarantee you all of us said something stupid at some point along the way. That's called human nature, unless you're just not human and you don't really care. And I was like, that's your best evidence? That means you don't have an abusive relationship at all. That's all you could find. And second thing, people go back and find it. What I predicted is the context of all the other clips would tell a different story, or watch to see if that disappears. And what's happened? All the ex-wife apparently has lost all the other clips, all the other video stuff. She was doing the new special computer for extortionists and criminals. And one of them is, instead of saying delete, it just says Hillary delete, Hillary delete, Hillary delete, Hillary delete. Apparently, and she has the same name.
I was going to say, wonder if she used bleach bit. I'll bring this up. It's a fair point. Crowder loves restrictive contracts for his employees, but not for him.
Yeah, and we can get into the business side of it, the politics side of it. It's because there's the law side, which is different than the business and politics, and people are conflating the two. People are saying, I don't like what this idea of a non-compete, or some people are saying they totally embrace non-competes, and the law is much more balanced than that. It doesn't fully defend non-competes. And in fact, it wouldn't surprise me if his non-competes are way too broad,
Yep.
which make them high risk, by the way.
Because under American law, it's the same principles under Canadian. Like you don't get to segment out the piece that was overbroad.
And over the last 15 years, non-competes often do not get affirmed in court. I've dealt with people in the Hollywood and entertainment industry, and the short answer is a non-compete. The logic from the employer is I'm going to invest a bunch of capital in you. I'm going to help create your public image, or I'm going to give you access to our methods, our sources, our training, our intellectual property, all of that. But in the entertainment industry, I'm giving you access to build your own market, build your own audience. And I want to know that I'm investing that for the benefit of me, the employer, not for your benefit, to our exclusion. And that's the logic of a non-compete. From the employee perspective, it's, hey, I just want a job. And if this isn't working out, I don't want to be prohibited from doing what my skill is. So that's where you get the political gap between the employee-employer perspective. But the law has been increasingly hostile. The law disfavors, in Texas even more so. They even have constitutional provisions on this that can be applicable. And I would argue U.S. constitutional can apply in certain instances. But again, they would only apply to a court enforcing it. Doesn't imply, not Gay Jared and even Lauren Southern and some others were suggesting somehow this could be unconstitutional, what a private employer does. That has nothing to do with the state at all. The Constitution doesn't apply there, folks. So the Constitution only applies when there's coercion or collusion with the state, like in the social media censorship context. It doesn't apply to just a private employer. So it's politically, rhetorically effective to say this is a free speech battle. Sorry, no, it's not. It has nothing to do with free speech. Not Gay Jared. It's one of
people mean
bad legal takes.
Now they mean colloquially. I'm lowering my volume a little bit because people said you were a little low, and I'm not going to bring you up, Robert. So now you guys can turn your volume up. But no, typically it's what 2 years is what's generally accepted and geographically limited, so you don't have a global non-compete.
And not only that, it often has to be real specific. And that was what courts increasingly do because they really disfavor. Like if Crowder's non-competes are really broad, he's at high risk because what more courts are doing. Here's what used to happen. If you were a contract lawyer, your incentive was to make it as broad as possible. The employee was often less legally sophisticated than the employer, would often go along with it without recognizing what their legal rights were. And even if they challenged it or contested it in court, the court would just limit it, would sort of blue pencil it to give it what its legal permissive scope was. And so you had no downside as an employer to a really broad non-compete. Courts started realizing that was problematic because all it did is it created it distorted incentives. So what they often do now is if your non-compete is too broad, they strike the whole thing. They don't give you any non-compete. So if Crowder's lawyers have written too broad of non-competes, they better reconsider that crafting and drafting. We don't know. Now, usually these days, it really has to be specific to the capital you invested in the individual. So for example, if you're a shoe salesman, it's limited in a particular market. They can limit you to 2 years for selling shoes, but even then it can be limited even further in terms of what's permissive. And if it's too broad, they just strike the whole thing. So non-competes are, first, they are industry standard practice, particularly here, right? Crowder's investing his capital, his asset, his platform in making someone else a star. And in that capacity, doesn't want to have spent all of his money for just someone else's profit. But there's limits to that. And so it should be directly, in other words, you can't be the not gay Jared character on another show for 2 years in this same space, not the entire entertainment industry, right? If it said the entire entertainment industry, that's going to be struck down as illegal. And then no aspect of the non-compete would be enforceable. He says he spoke to a lawyer, and it makes me doubt that the non-compete is as broad as some people are trying to imply, because it sounded like when he talked to his lawyer, the conclusion was the non-compete would likely be enforced. So unless he got his lawyers from, lawyersrus.com, then, which is possible with this guy, given some of his legal takes, then the non-compete must not be as broad as he's trying to imply that it is, or he got really bad legal advice.
Now, what Jared got, he's claiming he got some Form 202, which is calling him to provide documents in the context of another litigation.
Texas petition. So there's different ways to do it internationally. There's certain letters you can request, for example, for discovery through foreign governments. Basically, allows you not to sue someone, but to seek discovery from them when they have relevant information to another potential legal claim. And so, in particular, it looks like their focal point on him wasn't really him. It appears the focal point was proving the case against the ex. There's two cases involving between Crowder and his ex-wife. There's the family court case, divorce case, and a separate lawsuit involving her family, and her legal team and others to engage in a conspiracy to extort him using a sort of a public smear campaign that apparently people like Candace Owens are happy to jump on the train of. Okay, Candace apparently doesn't like non-disclosure agreements. I wonder if she has any with anybody, but leave that for another day, shall we? But that's what it appears to me, and it's what I suggested at the time, because the timing of the release of that video, the limit, it's what wasn't there. That's what we talked about at the time. Look at what's not there, not what is there, and that screamed they're planning on an extortion campaign. They're planning on a public smear campaign to extort Crowder to give him more money than they're legally entitled to. And these nitwits said so in writing. They actually said right in writing. And some of her lawyers, Laura Southern, seemed to think her lawyer was some poor schmuck down the street and she could barely afford anything on her $25,000 a month. Lauren might want to double check who the ex's lawyers are. Just research them a little bit, and you might come to a very different conclusion about their modus operandi. She's got lawyers around her that, let's just say, have a kind of Michael Avenatti smell about them. And where's Michael Avenatti today? Is he in a federal prison for extortion?
Robert, do I know who her attorney is? It's public knowledge.
Yeah. You can look it up. I'll let people look it up on their own. It'll be a fun little research project.
All right. Well, with that said, people, that's as much gossip as you're going to get out of this.
On the non-disclosure agreement aspect, that is commonplace. It is commonplace for it to not have a time limitation, unlike a non-compete. Almost every non-disclosure I've been involved in, hundreds and hundreds and hundreds of non-disclosure agreements. They rarely have a time limitation. Lauren Southern seemed to think I guess hers had a time limitation. That not most don't. That's very rare, especially in the Hollywood industry. And that's the two aspects of a non-disclosure agreement are, well, what's the employer's perspective? The employer's perspective is they don't want the access, giving somebody access to their life and their business to lead to their business being disparaged because of that access that the person previously had. But in the celebrity influencer world, it takes on a whole new dynamic, because one way to get money is to get access to a celebrity of any kind, and Crowder is a celebrity in his own way, and then monetize that access by sharing every secret you possibly know, every embarrassing piece of information you possibly know. So in the entertainment industry, it is universal for there to be a non-disclosure agreement, and quite frankly, quite reasonable. I had to advise one celebrity client how not to violate an NDA concerning another celebrity client once. And and finally got them to do it. They even had this crazy scheme for how they were going to get it, but c'est la vie. So that is very standard and has nothing to do with free speech. It has nothing to do with the First Amendment. It has to do with, I'm going to give you access to intimate information about my business and life. I don't want to have to pay the price for that and you monetizing it against me. That's a very reasonable business negotiation. Jared's complaints on that are unreasonable, untenable. And it's also clear he's been violating it left and right. I mean, he's just been ignoring the law entirely on non-disclosure agreements. And Crowder extraordinarily has not sued him yet. So the pitch and portrayal, I think people that have either political disagreements with Crowder, personal antagonism towards Crowder, or negative experiences in the divorce process from a woman's perspective, or negative experience with the legal system, are projecting that onto Crowder's case in a way that just doesn't fit Crowder's case. And I've said previously, I have no doubts Crowder might not be the easiest person to work for, but that's entirely different than the reasonableness of an NDA.
Well,
That's an eminently reasonable requirement for someone in his position.
It sort of goes back a little bit to the Lizzo thing. Like, you can't go work for Lizzo and then say, oh my goodness, then we had to go to a sex club in Amsterdam and eat the bananas out of someone's vajayjay. Like, Steven Crowder's got a bit of a set where they're rowdy, immature people making rowdy, immature, but insightful content. You can't just say, oh, but your name was gay, not gay Jared. What the hell do you think that work environment was going to be like? Not going to be abusive, like beating you with sticks, but it's going to be a bit of a saucy work environment. You don't get to that.
If he had any true hostile work environment claims that were separate and distinct from what the nature of that entertainment industry and their particular entertainment product was, then he would have been in a much better negotiating position. And it just seems to me like the negotiating position of both Jared and Crowder's ex-wife have been, we have secrets about you that we can share that will embarrass and humiliate you. So, and we will share those unless you give us lots of money. All right. That there is a word for that. It's called extortion.
Rob, it's just good negotiation.
Yeah, you got to walk that line, folks. People have been sued for extortion. Lawyers have been sued for writing settlement demand letters. Right? You have to be real careful. Now and then I'll get a client that'll suggest something foolish in that regard. Like, no. We can say this. We can't say that. But these people put it in writing, and I just have zero sympathy for that side of the aisle. Now, that's separate from, I do have sympathy with the discovery issues, which is, I'm dealing with this in a bunch of cases across the country where big corporations, where Lauren Southern is absolutely right, is parties with more legal means can beat the daylights out of people without legal means. That's definitely a problem. I don't know if it's this is the best example to use for that problem, when it appears that you have extortionate criminals who are mad about being exposed as extortionate criminals. But at the same time, there is a legitimate grievance about the way our legal system handles discovery.
Well, Mr. Giggle, I'm sure Jared actually has a non-compete because he started a social media management company 2 months after he left Crowder. I think he violated the non-solicitation clause trying to get clients. There you have it, people. All right, what we're going to do now?
I'm sure he did. And to my knowledge, Crowder didn't take any action. So it's like there are legitimate criticisms of non-competes, legitimate criticisms of non-disclosure agreements. They're just not applicable in the Steven Crowder case. And there's people that are rallying to the side of Jared and the ex and other people who are just making a mistake in doing so.
Well, they see it.
They're going to end up on the side of the Michael Avenattis of the world. Bad place to be, folks.
Well, it's a perceived underdog. They see, Crowder's the big bag.
There's some underdogs that are actual underdogs, and then there's the Stormy Daniels and Michael Avenattis of the world.